This particular talk is going to look at the Australian greenwashing inquiry, and I guess it has a number of synergies with some of the previous talks that we've had today. There are some similar themes to the regulation of advertising and sponsorship and promotions that we've seen for tobacco, alcohol and food. There's also kind of a perennial question about, well, how do you deal with misleading and deceptive information? There's a kind of an issue about, transnational corporations behaving in a way that it impacts upon public goods in relation to food and health and the environment. So the discussion of greenwashing is meant to be kind of a parallel and a kind of a counterpoint to some of the other areas that we've been looking at today. So we kind of have a sense of completeness in terms of how we look at these matters. So I've actually been kind of doing a lot of work on greenwashing over the past decade or so. Unfortunately, it's still kind of germinating into a publication at the moment of a larger size. I've been kind of thinking about how are current laws and regulations on greenwashing being enforced and utilised. Do there need to be further reforms to existing laws and regulations on greenwashing? Should there be comprehensive bans on fossil fuel advertising and promotions, like there is for tobacco advertising, promotions and sponsorship? So, I think one of the reasons why it's taken me a little bit long to finalise this particular project has been that the area keeps rising in importance. There has been a whole spate of new litigation. There has been various different policy investigations. It's always tricky sometimes to work out when the time is right to take action in relation to a topic and publish on a topic. And I guess I've kind of taken the view that we haven't really quite reached the critical moment, as it were. In an Australian context, the issue of greenwashing has really kind of come into a greater level of media attention with a push for a Senate inquiry by Senator Sarah Hanson-Young of the Greens for the 2023 Climate Integrity Summit. She gave a speech about the need to deal with greenwashing. She says it's important that we remember more than ever, Australians want to do the right thing by our environment. Watching our country burn and flood as a result of climate change has focused our minds. During the Black Summer bushfires, the environment became the #1 issue of importance to voters. The 3 years of COVID and lockdowns gave people time to reconnect with nature and reevaluate our priorities. These experiences are reflected in the choices that Australians are making as voters and as consumers. Consumers are voting with their hard-earned dollars. Businesses are wanting to do the right thing, but while Australians call for greater action on climate and environment, greenwashing becomes a bigger risk. In this place, the Australian Parliament, it is our job to ensure that the regulatory systems are robust so that we can transparently and with integrity take real action on the climate crisis. So she's had quite a bit of a connection with the Australia Institute. The Australia Institute were doing kind of a number of exposés on greenwashing. Sarah Hanson-Young, looking at that work, said, in Australia, where regulation remains weak and slow to catch up, it's safe to assume that the statistics are not much better, if not worse. Regulation, prosecution of greenwashing is only in its early stages. This pressure to regulate greenwashing is set to increase not just in Australia, but globally, with governments and industries on notice. So at her kind of instigation, the Australian Senate has kind of agreed with its Standing Committee on Environment and Communications to hold an inquiry into greenwashing. So the terms of reference that were kind of tabled was, an inquiry into greenwashing with particular reference to the environmental and sustainability claims made by companies and industries, including energy, vehicles, household products and appliances, food and drink packaging, cosmetics, clothing and footwear. The impact of misleading environmental sustainability claims on consumers, domestic and international examples of regulating companies' environmental and sustainability claims, advertising standards in relation to environmental and sustainability claims, legislative options to protect consumers from greenwashing in Australia, and any other related matters. So there's been lots of submissions that have been put in. They haven't really moved on to hearings. Essentially, the committee has been given an extension of time for the report. So the expectation is that there will be hearings into the topic of greenwashing in 2024. From a legal perspective, the topic of greenwashing can be a challenging one because it cuts across so many different regulatory fields. And perhaps one of the reasons why we don't have a very kind of clear response to the problem of greenwashing, the problem of misleading and deceptive representations about the environment. There have been problems in the way in which there are multiple regulators with kind of uncertain jurisdictions trying to deal with a similar issue. So it raises issues in terms of media and communications law, in terms of ad standards, consumer law, corporations law, clean energy and climate law, intellectual property. And I guess there are some other models as well. So the European Commission is trying to develop a very prescriptive directive on green claims. The UN Secretary General's Net Zero expert group has also been kind of issuing kind of recommendations about what should be done in relation to greenwashing. Antonio Guterres, the UN Secretary General, has said that there should be zero tolerance for greenwashing, particularly given various crises in relation to climate change and sustainability. I guess the fundamental problem in Australia is that our key organisation dealing with advertising has not necessarily worked very well in relation to environmental claims. So with media and communications law during the 2000s, there was a great excitement about shared regulation and self-regulation, and industry bodies were set up to try to regulate different elements of the media. So for advertising, we had the Ad Standards Board. Back in 2009, Choice was critical of the body and its new proposed green code, saying it would not be successful unless it is properly interpreted and enforced. It noted that really the Standards Board lacked the necessary expertise and clout to properly police green claims. So ad standards is meant to be kind of a community voice for complaints about advertising and marketing standards. But over a decade, there's been very few successful actions brought over environmental claims. So one of the few is over this particular ad. Life's better when you add gas. Natural gas not only saves you money on hot water cooking and heating, it's also better for the environment. So that's an example of a successful complaint was made about that particular advertisement, but there are many other complaints that have been unsuccessful, including kind of quite well constructed ones by the Environmental Defenders Office. I think part of the problem has been the Ad Standards Board has denied that there's a major problem in relation to greenwashing. So it is kind of, when pressed, has said that, you know, it's not really a major issue in its mind. Now with the kind of new inquiry underway, it's become kind of quite defensive about its future existence and has said that it's going to revisit and revise its green claims code and kind of take a different approach. I'm not sure that it will be effective. It should be said though that in the United Kingdom, the Ad Standards Board has been quite active and vocal and has upheld lots of complaints about advertising that engages in greenwashing. We have had a busy regulator in terms of the Australian Competition and Consumer Commission, not only dealing with vaping and cigarettes and misleading, deceptive representations made about food, particularly, when bread was baked and over such matters. It's also had an interest in the topic of green marketing. So it kind of issued guidelines to help interpret its usual consumer law provisions around stopping misleading and deceptive representations. So back in 2008, it was warning that companies are increasingly using environmental claims in an attempt to differentiate themselves and their products from competition. It issued some guidance on carbon claims and the Trade Practices Act back in 2008. It has taken a number of actions in the Federal Court of Australia in respect of green marketing and carbon offset claims. So the Federal Court declared that Holden had made false and misleading claims in its green campaign, which promoted the environmentally friendly nature of its Saab range of products. There's also been action over V8 supercars. There has been action over fridges and over sequestration of carbon. Perhaps the most important action was the action against Volkswagen over its diesel defeat devices. The Federal Court of Australia ordered Volkswagen to pay $125 million in penalties after it declared by consent that Volkswagen had breached Australian consumer law by making false representations about compliance with Australia's diesel emission standards. But it's also had some failures. So it kind of took action over so-called flushable wipes that were not actually flushable. And somehow that action was unsuccessful. The new chair of the ACCC has said that greenwashing is a priority and has undertaken an internet sweep, which has found widespread problems in respect of dubious environmental and sustainability claims. They have promised that they're going to take enforcement action and education action in relation to that. And there's also been some kind of complaints by organisations like Comms Declare and the Environmental Defenders Office. A recent example of a successful, action has been that Moo Premium Foods has given an undertaking over its 100% ocean plastic recycled tubs, given that that was seen to be kind of misleading and deceptive. So kind of a food dispute in some ways and a plastic dispute. ASIC has been a less effective regulator. So ASIC is really kind of operates in relation to corporations law. Really only since the Albanese government coming to power has the Commission really kind of taken seriously some of the problems about misrepresentations about whether practices or products are environmentally friendly. ASIC has been putting in place some new guidelines and they've got a number of investigations underway. They've fined Tower Energy $53,000 in its first action over greenwashing. And it is also busy pursuing some other entities like Vanguard Investments and Black Mountain Energy Limited over greenwashing. They've recently, at the start of this year, launched court proceedings against Mercer Superannuation for making misleading statements about the sustainable nature and characteristics of some of its superannuation investment options. I would note there's also been similar issues around greenwashing in relation to carbon credits. So the Clean Energy Regulator has been kind of concerned about that issue, but they have not been very prominent. I'm kind of quite interested in the topic of climate litigation. I have this whole batch of climate litigation, particularly overseas, in which some cities and some states bring action against oil companies alleging that they have made false and misleading representations about energy and the environment and climate. And projects like Exxon New have been kind of digging through the archives of companies to try to find evidence that the companies were saying one thing in public and another thing in private. We haven't really quite had that genre of action yet in Australia in terms of climate litigation. We've had a lot of climate litigation, but it hasn't gone down that route yet. But I think that's an area in which there could be more activity. Intellectual property is kind of a little bit of a curious area, and there hasn't really been enough attention given to the relationship between intellectual property and greenwashing. As Eric Lane kind of notes, intellectual property can be used in useful ways to kind of promote truly green products. Certification trademarks can be used to certify that certain marks satisfy certain conditions. There's some very well-known, famous certification marks in relation to the environment and sustainability. Sometimes you can have some much more kind of government-based ones. I remember being in Scandinavian countries and they had the Nordic Swan as a kind of a certification mark. You can also have individual companies or individuals seeking trademarks with environmental characteristics. So as long as they can satisfy that the trademark is distinctive inherently or for acquired distinctiveness, that they could possibly do that. But I think there's also kind of a problematic area of trademarks that make false and misleading environmental claims. So there's an interesting question about how does Australian consumer law interact with intellectual property laws, particularly around products that are misleading and deceptive. And sometimes you can have really interesting instances in which civil society organisations try to criticise the trademarks of fossil fuel companies. So Greenpeace, for instance, have been running campaigns against various different fossil fuel companies and energy companies. But they ran a particular one against the utility company AGL, labelling them Australia's biggest climate polluter. AGL responded by suing them for copyright infringement and trademark infringement. Largely, Greenpeace were able to kind of ward off that action in the Federal Court of Australia. They were able to demonstrate that many of their counter advertisements were a form of fair dealing for criticism review or for parody. Not all of them, but some of them. And the court was of the view that it wasn't really a trademark-based use of the mark in this particular case. So they weren't really kind of convinced by AGL's arguments about trademark infringement. Anyway, it was an interesting skirmish. I guess there's a lot of discussion now about, are there better models to deal with the problem of greenwashing? You know, have the existing models been sufficient to deal with this problem? The European Commission has been kind of developing a Green Claims Directive proposal with a common set of criteria against greenwashing and misleading environmental claims. It wants common criteria on how companies should substantiate environmental claims, clear requirements to address the proliferation and credibility challenges of environmental labels, and a sound system of independent verification. So I guess that's one of the proposals up for discussion in the Australian inquiry in terms of should we shift to a much more prescriptive model like this one. I guess the UN has also been kind of making its own recommendations about what should be done in relation to greenwashing. Guterres enlisted Catherine McKenna, former Environment Minister in Canada, to lead an expert group. And at the last climate COP, they made a number of recommendations about what needed to be done in terms of regulating net zero pledges in particular, but also they kind of emphasised, particularly McKenna, that the planet cannot afford delays, excuses or more greenwashing. I just want to wrap up by noting that there are some civil society groups who have been looking to tobacco control for inspiration about how to deal with the problem of greenwashing. So Clean Comms and a number of other organisations have argued that we need much more comprehensive prohibitions on certain sorts of companies engaging in advertising, sponsorship and promotion. So this has sometimes been a local campaign, so they've been lobbying local councils to have regulations about advertisements promoting fossil fuels, so kind of an ad ban model. And that has had some success, I guess, in certain kind of local councils. Some of the more progressive councils seem to be in favour of such bans. Sue Higginson, who's a New South Wales Greens MP, has kind of pushed for a bill at a state level to try to ban fossil fuel advertisements. That hasn't really progressed very far, but it's kind of an interesting legislative model. There's been also a kind of some discussion about, you know, should there be a binding treaty against fossil fuels, much like there is a tobacco treaty. But I guess it's kind of an ongoing issue, particularly in terms of advertising, sponsorship and promotion. In the excellent talk that we heard before about how omnipresent some of the food marketing is in our society, the same could be said about coal, oil and gas sponsorship in Australia, in terms of rugby teams, surfing clubs, and various other things. So there's been a lot of kind of complaints about really companies are using sponsorships to boost their reputation in certain ways that are perhaps misleading and deceptive. Even in terms of cultural events, you can have someone like Tim Winton, author of Cloud Street and various other novels in Australia, kind of arguing that really such companies shouldn't be allowed to engage in such advertisements and promotions and sponsorships. We really need to have a much more effective means of stopping greenwashing by the fossil fuel industry. Anyway, thank you very much.